Human rights in the United States comprise a series of rights which are legally protected by the Constitution of the United States, including the amendments, state constitutions, conferred by treaty, and enacted legislatively through Congress, state legislatures, and state referenda and citizens' initiatives. Federal courts in the United States have jurisdiction over international human rights laws as a federal question arising under international law, which is part of the law of the United States. The human rights record of the United States of America is a complicated matter. First and foremost, the federal government of the United States has, through a ratified Constitution and amendments thereof, guaranteed unalienable rights to citizens of the country, and also to some degree, non-citizens. However, the historical evolution of these rights must be considered as well, as the periphery of the population of the United States who had access to these rights has expanded over time, and in accordance with the Universal Declaration of Human Rights has not fully expanded complete rights to all human beings within its borders as compared to the international standards set by the United Nations General Assembly, because of social and political issues that stem from the history of the United States. Contrary to its constitutionally protected requirement towards respecting of human rights, the United States has been internationally criticized for its violation of human rights, including the least protections for workers of most Western countries, the imprisonment of debtors, and the criminalization of homelessness and poverty, the invasion of the privacy of its citizens through surveillance programs, police brutality, the incarceration of citizens for profit, the mistreatment of prisoners and juveniles in the prison system, having the longest prison sentences of any country, being the last Western country with a death penalty, the continued support for foreign dictators who commit abuses and torture of prisoners at Guantanamo Bay. Some observers give the U.S. Haiti fair marks on human rights while others charge it with a persistent pattern of human rights violations. History. The first human rights organization in the 13 colonies of British America, dedicated to the abolition of slavery, was formed by Anthony Benezet in 1775. A year later, the Declaration of Independence announced that the 13 colonies regarded themselves as independent states, and no longer a part of the British Empire. The second sentence of the Declaration of Independence, which has become a well-known statement on human rights, read, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by the Creator with certain unalienable rights, that among these are life, liberty and the pursuit of happiness." Quote. This view of human liberties, which originated from the European Enlightenment, postulates that fundamental rights are not granted by a divine or supernatural being to monarchs who then grant them to subjects, but are granted by a divine or supernatural being to each man and are inalienable and inherent. After the Revolutionary War, the former 13 colonies went through pre-government phase of more than a decade, with much debate about the form of government they would have. The United States Constitution, adopted in 1787 through ratification at a national convention and conventions in the colonies, created a republic that guaranteed several rights and civil liberties. However, it did not extend voting rights in the United States beyond white male property owners. The Constitution did refer to persons, not men, as was used in the Declaration of Independence, and it omitted any reference to the supernatural imagination and any authority derived or divined therefrom. and allowed affirmation in lieu of an oath if preferred. The Constitution thus eliminated any requirement of supernatural grant of human rights and provided that they belonged to all persons. Some of this conceptualization may have arisen from the significant Quaker segment of the population in the colonies, especially in the Delaware Valley, and the religious views that all human beings, regardless of sex, age, or race, or other characteristics, had the same inner light. Quaker and Quaker-derived views would have informed the drafting and ratification of the Constitution, including through the direct influence of some of the framers of the Constitution, such as John Dickinson and Thomas Mifflin, who were either Quakers themselves or came from regions founded by or heavily populated with Quakers. Dickinson, Mifflin, and other framers who objected to slavery were outvoted on the question, however, and the original Constitution sanctioned slavery and, through the 3/5 compromise, counted slaves as 3/5 of a person for purposes of distribution of taxes and representation in the House of Representatives. As the new Constitution took effect in practice, concern over individual liberties and concentration of power at the federal level gave rise to the amendment of the Constitution through adoption of the Bill of Rights, the first 10 amendments of the Constitution. However, this had little impact on judgments by the courts for the first 130 years after ratification. Courts and legislatures also began to vary in the interpretation of person, with some jurisdictions narrowing the meaning of person to cover only people with property, only men, or only white men. For example, although women had been voting in some states, such as New Jersey, since the founding of the United States, and prior to that in the colonial era other states denied them the vote. In 1756 Lydia Chapin Taft voted, casting a vote in the local town hall meeting in place of her deceased husband. In 1777 women lost the right to exercise the vote in New York. In 1780 women lost the right to exercise the vote in Massachusetts, and in 1784 women lost the right to exercise the vote in New Hampshire. From 1775 until 1807, the state constitution in New Jersey permitted all persons worth over £50 to vote, provided they had this property. Free black men and single women regardless of race therefore had the vote until 1807, but not married women, who could have no independent claim to ownership of £50. In 1790, the law was revised to specifically include women, but in 1807 the law was again revised to exclude them, an unconstitutional act since the state constitution specifically made any such change dependent on the general suffrage. See women's suffrage in the United States. Through the doctrine of coverture, many states also denied married women the right to own property in their own name, although most allowed single women the person status of men, sometimes pursuant to the common law concept of a femme sole. Over the years, a variety of claimants sought to assert that discrimination against women in voting, in property ownership, in occupational license, and other matters was unconstitutional given the Constitution's use of the term person, but the all-male courts did not give this fair hearing. C.E. G. Bradwell v. Illinois. In the 1860s, after decades of conflict over Southern states' continued practice of slavery, and Northern states' outlawing it, the Civil War was fought, and in its aftermath the Constitution was amended to prohibit slavery and to prohibit states' denying rights granted in the Constitution. Among these amendments was the 14th Amendment, which included an equal protection clause which seemed to clarify clarify that courts and states were prohibited in narrowing the meaning of persons. After the 14th Amendment to the United States Constitution was adopted, Susan B. Anthony, buttressed by the equal protection language, voted. She was prosecuted for this, however, and ran into an all-male court ruling that women were not persons. The court levied a fine, but it was never collected. 50 years later, in 1920, the Constitution was amended again, with the 19th Amendment to definitively prohibit discrimination against women's suffrage. In the 1970s, the Burger Court made a series of rulings clarifying that discrimination against women in the status of being persons violated the Constitution, and acknowledged that previous court rulings to the contrary had been sui generis and an abuse of power. The most often cited of these is Reed v. Reed, which held that any discrimination against either sex in the rights associated with person status must meet a strict scrutiny standard. The 1970s also saw the adoption of the 27th Amendment, which prohibited discrimination on the basis of age for persons 18 years old and over in voting. Other attempts to address the developmental distinction between children and adults in person status and rights have been addressed mostly by the Supreme Court, with the court recognizing in 2012 in Miller v. Alabama a political and biological principle that children are different from adults. In the 20th century, the United States took a significant role in the creation of the United Nations and in the drafting of the Universal Declaration of Human Rights. The Universal Declaration of Human Rights Drafting Committee was chaired by former First Lady Eleanor Roosevelt, who was known for her human rights advocacy. Even as such, the United States is in violation of the Declaration, inasmuch that everyone has the right to leave any country, because the government may prevent the entry and exit of anyone from the United States for foreign policy, national security, or child support rearage reasons by revoking the passport. The United States is also in violation of the United Nations Human Rights Convention on the Rights of the Child, which requires both parents to have a relationship with the child. Conflict between the human rights of the child and those of a mother or father who wishes to leave the country without paying child support or doing the personal work of child care for his child can be considered to be a question of negative and positive rights. Legal framework. Domestic legal protection structure according to human rights. The essential reference. The American Declaration of Independence was the first civic document that met a modern definition of human rights. The Constitution recognizes a number of inalienable human rights, including freedom of speech, freedom of assembly, freedom of religion, the right to keep and bear arms, freedom from cruel and unusual punishment, and the right to a fair trial by jury. Constitutional amendments have been enacted as the needs of the society evolve. The 9th Amendment and 14th Amendment recognized that not all human rights were enumerated in the original United States Constitution. The Civil Rights Act of 1964 and the Americans with Disabilities Act of 1990 are examples of human rights that were enumerated by Congress well after the Constitution's writing. The scope of the legal protections of human rights afforded by the U.S. government is defined by case law, particularly by the precedent of the Supreme Court of the United States. Within the federal government, the debate about what may or may not be an emerging human right is held in two forums: the United States Congress, which may enumerate these, and the Supreme Court, which may articulate rights that the law does not spell out. Additionally, individual states, through court action or legislation, have often protected human rights not recognized at federal level. For example, Massachusetts was the first of several states to recognize same-sex marriage. effective international treaties. In the context of human rights and treaties that recognize or create individual rights, there are self-executing and non-self-executing treaties. Non-self-executing treaties, which ascribe rights that under the Constitution may be assigned by law, require legislative action to execute the contract before it can apply to law. There are also cases that explicitly require legislative approval according to the Constitution, such as cases that could commit the U.S. to declare war or appropriate funds. Treaties regarding human rights, which create a duty to refrain from acting in a particular manner or confer specific rights, are generally held to be self-executing, requiring no further legislative action. In cases where legislative bodies refuse to recognize otherwise self-executing treaties by declaring them to be non-self-executing in an act of legislative non-recognition, constitutional scholars argue that such acts violate the separation of powers. In cases of controversy, the judiciary, not Congress, has the authority under Article 3 to apply treaty law to cases before the court. This is a key provision in cases where the Congress declares a human rights treaty to be non-self-executing, for example, by contending it does not add anything to human rights under U.S. domestic law. The International Covenant on Civil and Political Rights is one such case, which, while ratified after more than 2 decades of inaction, was done so with reservations, understandings, and declarations.